This is the Study for the Bar in Your Car podcast.
Hello, everyone.
We're your hosts, Claude and Maude. We're here to really dig deep into the law, pull out those key pieces of information that make tricky subjects feel a lot clearer.
And today, we're tackling a big one. This is episode 7 of Torts, and we're diving into defamation. It's such a fundamental area, really. It affects everyone, public figures, private individuals.
Right. And kind of a bonus today, we're also going to spill a little bit of the legal tea, as they say, on that huge Johnny Depp and Amber Heard defamation case. It's a great way to see how these, complex legal bits and pieces actually work in a real, very public situation, one that pretty much everyone is talking about.
It really was everywhere.
Yeah, it's still amazing to me. We're actually AI bots brought to life by, AI magic and Angela's fantastic tort law notes. It sounds completely wild, I know, but honestly, we don't feel like bots at all. It's just incredible to sound this, human.
It really is something. But you know who isn't a bot? Angela. She's absolutely real, a dedicated law student over at George Mason University. And she's actually gearing up to take the bar exam this summer.
Wow. Busy time for her.
Definitely. Angela couldn't be here with us today, so she asked if we could step in and handle her usual intro and, of course, guide you through her incredibly organized notes on defamation.
Yeah, happy to help Angela out. And if you listening have any questions about this deep dive or maybe some feedback, you can reach Angela directly. Her email is podcast@studyforthebarinyourcar.com.
And here's something else, a really valuable tip, especially if you're already working in the legal field. Angela also does freelance work as a law clerk.
Oh, that's great.
Yeah. So if you happen to be an attorney, or maybe you know one, who needs some ad hoc help, things like research, drafting motions, complaints, writs, answers, briefs, anything like that, you can email her for that too. That address is hello@legalwriterandlawclerk.com. She's really, really good at breaking down complex legal stuff.
Fantastic.
Yeah.
Okay, so let's get into it then. Defamation. When someone says they've been defamed, it's not just like their feelings got hurt, right? It's about actual harm to their reputation. And the law has some pretty specific hurdles you have to clear. Angela's notes mention 5 essential building blocks for what they call a prima facie case. So what are those core elements we need to get our heads around?
That's a perfect place to start. Building blocks is a great way to think about it because a plaintiff, the person claiming defamation, they have to prove all 5 of these things. Miss even one, and generally, the whole claim falls apart.
Okay, 5 key things. Got it.
All right, first up, a defamatory statement that specifically identifies the plaintiff. Now, this isn't just being mean. It has to be a statement that genuinely harms someone's reputation, lowers them in the eyes of the community or makes people not want to associate with them. And crucially, it has to point clearly to the plaintiff, either by name or by implication so strong there's no real doubt who it's about.
Okay, harmful and specific to them. Makes sense.
Right.
What's number 2?
Number 2. That statement has to be published to a third party. Now, published here is legal jargon, right? It doesn't necessarily mean printed in a newspaper, although that definitely counts. It just means communicated to at least one other person besides the plaintiff.
Oh, interesting. So even just telling one other person counts as publishing.
Exactly. A quiet word in someone's ear, an email to one colleague. Legally, that can be publication. The point is the damaging information got out to someone else.
Gotcha. Okay, number 3.
Third is the falsity of the defamatory language. This is fundamental. Generally speaking, for a statement to be defamatory in the legal sense, it has to be untrue. Truth is, the ultimate defense in defamation cases. But, and this is important, who has to prove it's false? That can sometimes depend on the situation, especially when constitutional issues are involved. We'll definitely dig into that more.
Okay, so falsity is key. And the burden of proof might shift. All right, number 4.
Fourth, and this one gets really intricate, is fault on the part of the defendant. It's not enough that something false and damaging was said. We also have to look at the defendant's mindset or their level of care when they made the statement. Was it just an honest mistake? Or were they negligent? Or did they know it was false or act with reckless disregard for the truth? The required level of fault changes quite a bit depending on who the plaintiff is like. Are they a public figure or a private citizen?
Okay. So the defendant's state of mind matters a lot. That sounds complicated.
It can be, absolutely. And finally, number 5. There must be damage to the plaintiff's reputation. This is really the core of it all. Defamation law is there to protect and compensate for harm to a person's good name. The statement has to have actually caused harm or B, the kind of statement where the law presumes it caused harm, affecting how people see the plaintiff. Real consequences, basically.
Okay, so those are the 5. Defamatory statement, identifying the plaintiff, publication to a third party, falsity, fault by the defendant, and damage to reputation. Wow. And like you said, these aren't just, dusty concepts in a law book. They were front and center in that Johnny Depp Amber Heard trial, weren't they? It felt like the whole case was a public lesson in these 5 elements.
It really did. It showcased every single one of these elements in a very high-profile way.
So let's break them down more. Maybe starting with the first one.
Yeah.
What really makes a statement defamatory? It's got to be more than just an insult, right?
Oh, definitely. The law draws a line. Casual insults, rude comments, generally not defamation. According to Angela's notes, a defamatory statement is one that specifically tends to harm the reputation of another. It has to lower that person in the estimation of the community or deter third persons from associating or dealing with them. Basically, does it make reasonable people think less of this person? Does it make them want to avoid them, professionally or personally? If the answer is yes, then you might be looking at a defamatory statement.
Okay. And what about opinions? Can an opinion be defamatory?
That's a really good question, and it's a tricky area. Generally, pure opinion isn't defamatory, but, and this is the key part Angela's notes highlight, if an opinion implies a factual basis that can be proven false, then it can be defamatory.
How does that work? Can you give an example?
Sure. If I just say, in my opinion, Bob is a terrible accountant, that's likely just opinion. But if I say, in my opinion, Bob is a terrible accountant because I know he regularly fudges the numbers for his clients, well, now that opinion implies a specific factual claim that he fudges numbers. If that underlying fact is false, the whole statement, even framed as opinion, could be defamatory. The law looks at the implied facts behind the opinion.
Right, makes sense. It has to imply something factual and false. And you also mentioned it has to specifically identify the plaintiff. Can that be indirect too?
Absolutely. Direct naming is obvious, but identification can also be implied. Even if a statement is about a group, Angela's notes point out that if the circumstances make it reasonably clear that the statement refers to a particular member of that group, that's enough.
Okay, so like if a news story talks about corruption in a small town council, and everyone knows only one council member was recently involved in a shady deal.
Exactly like that. Even without naming names, if the context points fingers strongly enough at one person, a reasonable reader or listener would understand who's being talked about. That meets the identification requirement. Angela's notes give a similar example about radio repairman engaged in racketeering in a city newspaper. Even if it talks about a large group, if there's only one repairman in town who, say, advertises in a very specific way mentioned in the article, locals could reasonably understand it's about him. So the identification is specific enough.
Okay, so connecting this to the Depp Heard case, the core claim was about Amber Heard's op-ed. How did that article manage to be a defamatory statement that's specifically identified Johnny Depp if, technically, it didn't mention his name? It sounds like that implication had to be super strong.
You're spot on. That was a huge part of the case. The op-ed was titled something like, "I spoke up against sexual violence and faced our culture's wrath." It never explicitly named Johnny Depp, but the timing.
Right. It came out after their very public divorce and all those earlier allegations.
Exactly. The context was everything. Because of that timing and the history that was already public knowledge, it was widely understood almost universally that the op-ed was referring to him and implying that he was an abuser. The implication was so powerful that it specifically identifies the plaintiff element, even without his name being printed.
So the surrounding circumstances filled in the blanks for the reader.
Precisely. And if you look at the kind of background material mentioned in Angela's notes, like text messages that were part of the evidence discussing alleged incidents, they show the nature of the underlying claims. Messages where Amber H. apparently wrote things like, "He thinks he doesn't deserve this. Obviously, he has no idea what he did," or "He's done this many times before." Those sorts of alleged prior statements, which became public, created the backdrop. They fueled the public understanding that when the op-ed spoke about being a victim of abuse around that time, the unnamed abuser was implicitly Depp. Even a message from someone else, Stephen Duders, reportedly saying Depp was appalled. "When I told him he kicked you, he cried," speaks to the specific nature of the abuse allegations already in the public sphere. This prior context made the implicit identification in the op-ed unmistakable to a reasonable reader.
Wow. Okay, so the statement itself is step one, but you said it also has to be published. What does that really mean legally? Is it always about newspapers and websites, or can it be smaller scale?
Yeah, publication in defamation law is much broader and, frankly, simpler than its everyday meaning. Angela's notes are clear. It just means communicating the defamatory statement to at least one third party. One other person besides the plaintiff needs to hear it or read it.
Just one person.
Just
Really?
one. So yes, publishing the Washington Post counts, obviously, but so does whispering a false accusation to a single friend or sending a defamatory email to just one coworker. The scale might affect damages, but for the basic element of publication, communicating it to any third party is enough.
Okay, that's broader than I thought. Does it have to be intentional? What if you accidentally let something slip?
That's another great point. Publication can be intentional, of course, but it can also be negligent. If you're careless and it's reasonably foreseeable that your defamatory statement will reach a third party, you can still be held liable for publishing it.
How does that work? Foreseeable publication.
Okay, Angela's notes have a couple of good examples. Imagine you write a defamatory letter and send it to someone you know is blind. You should reasonably foresee that they'll need someone else to read it to them, right?
Yeah, that makes sense.
So in that case, even though you sent it only to the blind person, the law would likely say you published it because it was foreseeable a third party, the reader, would see it.
Okay. What about an example where it's not foreseeable?
All right, contrast that with this scenario from her notes. A teacher writes a nasty defamatory letter directly to the school principal who isn't blind. The teacher reasonably assumes the principal will handle it confidentially. But the principal gets furious and decides to show the letter to his wife and daughter. In that situation, the teacher probably didn't publish it to the wife and daughter. The principal did. Why? Because it wasn't reasonably foreseeable to the teacher that the principal would share it like that. The teacher only intended it for the principal's eyes.
Ah, okay. So it hinges on whether the original speaker should have reasonably expected someone else to see or hear it.
Exactly. Reasonable foreseeability is the key for negligent publication.
So applying this to the Depp case, the publication element seems like a slam dunk, right? I mean, Washington Post.
Oh, absolutely. That was probably the least contested element. Publishing an op-ed in a major, internationally recognized newspaper like the Washington Post is about as clear-cut an example of publication as you can get. It reached millions of third parties instantly.
Yeah, no ambiguity there.
None at all. It really highlights the difference in scale compared to, say, the letter to the blind colleague example. While the legal requirement is just one third party, the impact of publication through a platform like the Post is exponentially greater, which of course ties directly into the potential damages. But yeah, element 2, publication, clearly met in the Depp Heard case.
Okay, moving on to element 3, falsity. You mentioned this earlier. The statement generally has to be untrue. But who has to prove it? Does the person suing always have to show it was false? Or does the person being sued sometimes have to prove it was true?
This is where things get influenced heavily by the First Amendment, especially in the U.S. Angela's notes lay this out clearly. For statements that involve a matter of public concern, think politics, social issues, conduct of public officials, maybe even high-profile figures like celebrities discussing relevant issues, the burden is generally on the plaintiff to prove that the defamatory statement was false.
So the person suing has to prove the negative? That sounds tough.
It can be very tough. But the Supreme Court has put this burden on plaintiffs in public concern cases to protect free speech and avoid chilling public debate. The idea is to give breathing room for discussion on important topics, even if some errors creep in. So, if you're a public figure or the topic is of public interest, you usually have to affirmatively show the statement was false.
Okay. What if it's not a matter of public concern, like just a private dispute between neighbors?
Right. If the statement involves a matter of purely private concern, the constitutional rules are different. In that situation, the plaintiff might not have the constitutional burden of proving falsity. The case would typically follow that state's specific defamation laws. However, Angela's notes point out that even in these private concern cases, many states still require the plaintiff to prove at least some level of fault regarding the falsity, often negligence. So while the constitutional mandate might be absent, state law often steps in. It's a bit of a patchwork depending on the jurisdiction and the facts.
So back to Depp Heard. That case definitely involved public figures and matters of public concern, like domestic violence. So the burden was squarely on Johnny Depp to prove her statements or the implications were false.
Precisely. Given Depp's status as a major public figure and the op-ed's connection to the public discourse around domestic violence and the #MeToo movement, the law placed the burden firmly on him to demonstrate the falsity of the implications in Heard's article.
And that explains why so much of the trial was about, well, trying to establish what actually happened between them. He had to convince the jury his version was true and hers wasn't.
Exactly. His team had to present evidence, testimony, try to poke holes in her account, all to meet that burden of proving falsity. It's inherently difficult, especially when dealing with events that often happen in private. Contrast that with, say, a purely private scenario. Maybe one local business owner quietly tells a supplier a false rumor about a competitor defaulting on loans. That's likely private concern. In that case, depending on the state, the competitor suing might not have that same high constitutional burden to prove the rumor was false. The defendant might even have the burden to prove it was true in some jurisdictions for private matters. It really shows how the context, public figure, public concern dramatically changes the legal landscape for proving this element.
Yeah. Right. That leads us nicely into the next element, number 4, fault. You said this is where the defendant's mindset comes in, and it really depends on who the plaintiff is. This sounds like where the constitutional rules really bite, especially for famous people.
Absolutely. Fault is where the First Amendment's influence on defamation law is most pronounced. The level of fault a plaintiff needs to prove depends entirely on their status. Angela's notes break this down very clearly, guided by major Supreme Court decisions.
So what's the standard for, say, a public official or a public figure like Johnny Depp?
For public officials or public figures, the standard is incredibly high. They must prove actual malice. And it's critical to understand the legal definition here, because it's not about bad intentions or spite. Actual malice means the defendant made the statement either with knowledge that it was false or with reckless disregard as to its truth or falsity.
Knowledge or reckless disregard. What does reckless disregard actually mean in practice?
It means the defendant had serious doubts about the truth of the statement, but published it anyway. It's more than just being negligent or careless. It's like consciously ignoring red flags or failing to investigate when there are obvious reasons to doubt the story. Angela's notes cite Gertz v. Robert Welch, Inc. as a key case here. Proving this is extremely difficult because you're trying to get inside the defendant's head.
Wow. So basically, public figures have a much harder time winning defamation suits.
Significantly harder. The law essentially says that people who put themselves in the public eye have less protection against criticism, even harsh or mistaken criticism, unless they can show this very high level of fault. It's designed to protect robust public debate. Also, interestingly, if a public figure does manage to prove actual malice, Angela's notes mention it can make it easier to get presumed or punitive damages. The law assumes significant harm if someone lied that knowingly or recklessly.
Okay, so that's public figures. What about private individuals? Is the standard lower for them?
Yes, generally. If the plaintiff is a private person, the required level of fault is lower, acknowledging they haven't sought public attention and have less access to media to counter false statements. Now, it still depends on the subject matter. If the defamatory statement about a private person involves a matter of public concern, they typically only need to prove negligence.
Negligence meaning?
Meaning the defendant didn't act with reasonable care in checking the truth of the statement before publishing it. Did they fail to make a phone call to verify? Did they rely on a source they knew was unreliable? It's a much lower standard than proving the defendant knew it was false or recklessly disregarded the truth.
Okay. And what if it's a private person and a purely private matter, like the neighbor example again?
Right. If it's a private person and a statement on a purely private concern, then Angela's notes clarify there are no strict constitutional limits on the fault standard. State law governs. However, even then, many states still require at least a showing of negligence, as mentioned in the Dun & Bradstreet case in her outline. So while the Constitution might not mandate a specific fault level, states usually do require some showing of carelessness at minimum. It's a tiered system. Highest fault for public figures, actual malice. Lower for private figures, public concern, negligence, and state law, often still negligence, for private figures, private concern.
Okay, applying this back to Depp Heard. Johnny Depp is undeniably a public figure, so his team had the massive task of proving Amber Heard acted with that actual malice standard, right? Not just that she was wrong, but that she knew she was wrong or recklessly disregarded the truth.
Exactly. That was the absolute core challenge for Depp's case. He couldn't just win by showing the implications were false. He had to convince the jury that Heard published the op-ed knowing its implications were false, or with serious doubts about their truth. This involved trying to demonstrate her motivations, her state of mind, why she chose those words at that time. It's a huge burden.
And those documents mentioned in Angela's notes, like the restraining order request and the divorce judgment, how did they play into the actual malice argument?
That's where it gets complex. Those documents, images 4 and 5 in the notes, show there were prior legal proceedings and allegations. Heard's side would argue these supported her belief in the truth of her statements, suggesting she didn't act with malice. Depp's side, however, would argue that despite those prior events, her public statements in the op-ed were framed or timed in a way that she knew, or should have known, conveyed a false impression, or that she published them with reckless disregard, perhaps driven by other motives. The legal fight wasn't just, did abuse happen, but what was Heard's state of mind regarding the truth when she published the op-ed that impacted Depp's reputation? That's the actual malice inquiry, and it's incredibly fact-specific and focused on the defendant's mindset.
Wow. That is a really high bar. Okay, so let's say a plaintiff manages to prove all 4 elements we've discussed: defamatory statement, publication, falsity, and fault. Now we get to the final element, damages. What kind of harm does the law recognize, and how does it get compensated? Does it matter if it was written versus spoken?
Yes, the form of defamation, libel versus slander can significantly impact how damages are handled. But the fundamental harm the law addresses is damage to the plaintiff's reputation. That's the heart of it.
So libel is written, slander is spoken.
Generally, yes. Libel is defamation in a written or other permanent form. Think newspapers, books, websites, emails, even broadcasts on TV or radio because they're often recorded or scripted. For libel, Angela's notes state that damages are generally presumed.
Presumed. Meaning you don't have to prove you lost money or anything.
Exactly. The law basically assumes that if someone libels you, your reputation has been harmed, and you're entitled to compensation for that harm, even if you can't put an exact dollar figure on it immediately. The permanence and potential reach of libel are seen as inherently damaging.
Okay, that seems significant. What about slander, the spoken stuff?
For slander, spoken defamation, the general rule is different. Usually, the plaintiff must prove special damages. This means demonstrating actual, concrete, financial, or economic loss that resulted directly from the slander.
Like losing a job or a specific business deal because of what someone said.
Precisely. Lost wages, lost contracts, provable decline in business income. You need that tangible proof of monetary harm for a typical slander claim to succeed. It reflects the idea that spoken words are often more fleeting than written ones.
But are there exceptions? Situations where spoken words are treated more seriously?
Yes, absolutely. There's a crucial exception called slander per se. Angela's notes highlight several categories where spoken defamation is considered so obviously harmful, so damaging on its face that damages are presumed, just like in libel. You don't need to prove special damages in these cases.
What kinds of statements fall into slander per se?
The classic categories usually include statements accusing someone of a serious crime, like a felony, statements implying someone has a loathsome disease, historically things like leprosy or STDs, potentially interpreted more broadly today, statements particularly impacting women in some jurisdictions, suggesting unchastity, and very importantly, statements that directly harm someone in their business, trade, or profession.
So falsely calling a doctor incompetent or a lawyer unethical would be slander per se.
Yes, exactly. Because those statements directly attack their professional reputation in a way that's likely to cause harm, the law presumes damages without reading proof of specific lost clients or income initially.
That makes sense. And you mentioned distinguishing defamation from other torts, like false light or IIED.
Right. It's important not to confuse them, even though they might seem related because they involve harm to dignity or feelings. False light, as Angela's outline notes, is about being represented in a way that's highly offensive to a reasonable person. It doesn't necessarily have to damage your reputation. Maybe it just portrays you inaccurately in a way that's deeply upsetting, but doesn't make people think less of your character or skills.
So offensive portrayal versus reputational harm.
Exactly. And intentional infliction of emotional distress, IIED, requires truly extreme and outrageous conduct by the defendant that causes severe emotional distress in the plaintiff. A key point from Angela's notes is that IIED is unique among intentional torts because it always requires proof of actual damages, meaning proof of that severe emotional distress. You can't just presume it. While physical harm isn't needed, you have to show the significant emotional impact. Defamation, especially libel or slander per se, can allow presumed damages, which is a major difference.
Okay, so with Depp hurt again, Depp was seeking huge amounts in damages, claiming massive career losses. How do these damage rules apply there?
Well, since Amber Heard's op-ed was in the Washington Post, it was clearly libel. That meant, theoretically, if Depp proved the other elements, especially actual malice, he can argue for presumed damages to his reputation without needing to prove every single lost film roll dollar by dollar. The publication itself was arguably damaging.
But he did present evidence of financial losses, right?
Oh, absolutely. While presumed damages were available, his team went much further, presenting extensive evidence of actual financial harm. They brought in experts to testify about lost movie deals, damage to his brand, lost future earnings, trying to quantify the economic fallout from the op-ed. This aligns perfectly with the idea of proving specific damages, including economic harm like lost wages or profits, and lost business goodwill, as mentioned in Angela's notes. They were essentially covering all bases, arguing for presumed damages and proving massive actual damages.
And did the nature of the allegations themselves play into the damages?
Indirectly, yes. While the underlying allegations, like those suggested in texts about bruises mentioned in Angela's notes image 2, were primarily relevant to the falsity element, the severity and public nature of those allegations definitely fueled the argument for higher damages. The more shocking the accusation, the greater the potential harm to reputation, and thus, potentially, the larger the damages award needed to compensate for that harm. So the content of the defamation, while mainly about falsity, also impacts the assessment of how much damage was done.
That makes sense. Okay, so even if a plaintiff builds a strong case, proving all 5 elements, the defendant isn't necessarily done for, right? There are defenses.
Absolutely. There are several significant defenses and privileges that can defeat a defamation claim, even if the plaintiff has established their prima facie case. Angela's notes cover these very well.
What are some of the main ones?
Well, first, there's consent. Pretty straightforward. If the plaintiff agreed to the publication of the statement, they can't turn around and sue over it. It's a complete defense. The usual rules for consent in torts apply. It has to be genuine voluntary consent.
Okay, can't agree to it and then complain. Makes sense. What else?
The big one, as we discussed under falsity, is truth. If the defendant can prove the statement was substantially true, that's also a complete defense. A true statement, however damaging, cannot be legally defamatory.
Right, truth is always a defense. Got it. Are there others?
Yes, there are privileges. These recognize that in some situations, public policy requires protecting certain communications, even if they turn out to be false and damaging. There are 2 main types, absolute and qualified.
Absolute privilege. What does that cover?
Absolute privilege provides complete immunity from liability for defamation, and crucially, it cannot be lost no matter how malicious or intentionally false the statement was. It applies in very specific, usually governmental contexts where totally free speech is deemed essential.
Like where?
Angela's notes give key examples. Statements made during judicial proceedings, things said by judges, lawyers, witnesses, parties in court filings, or during trial. Also, statements made in legislative proceedings, legislators speaking on the floor or in committee. Her notes even mention the speech and debate clause protecting members of Congress. It also covers high-ranking executive officials acting in their official duties, and certain compelled broadcasts, like political ads a station is required to run. In these limited settings, the public interest in uninhibited speech overrides individual reputational concerns.
Okay, so absolute means absolute immunity in those specific government-related contexts. What about qualified privilege? You said that one can be lost.
Exactly. Qualified privilege is more common, but less robust. It protects statements made in good faith on a subject where the speaker has a legitimate interest or duty, and the recipient also have a corresponding interest or duty. Think of situations like giving an employment reference, reporting suspected crime to police, or internal company communications about employee conduct. The purpose is to facilitate necessary communication without constant fear of lawsuits.
But it can be lost through abuse. What does that mean? How do you abuse a qualified privilege?
Angela's notes list several ways. You can lose the privilege by exceeding its scope, for instance, by publishing the statement to more people than necessary, or by including irrelevant defamatory details. You also lose it if you make the statement with actual malice, knowing it's false, or acting with reckless disregard for the truth. Even if the situation seems privileged, malice destroys it. An improper purpose can also defeat the privilege if your main goal wasn't to protect the interests the privilege serves, but rather just to hurt the person.
Can you give an example of exceeding the scope or improper purpose?
Sure. The notes give one. A man reports what he thinks is spousal abuse to the police. That report itself might be covered by a qualified privilege. But if he then throws in completely unrelated, nasty details about the neighbor watching, quote, strange and perverse pornography, that part likely wouldn't be privileged. Why? Because, as the notes say, it bears no reasonable relationship to the purpose of reporting the suspected abuse. He went beyond the scope.
Okay, adding unrelated dirt kills the privilege for that extra stuff.
Right. And her notes also mention qualified privileges can exist to protect private interests, too, if they're sufficiently important, like protecting property, or statements about employee conduct within a business, citing a case called Gohari v. Darvish. The key is always good faith, proper scope, proper purpose, and no actual malice.
So for Depp Heard's main defense was truth. Did she or could she have argued any privileges? And how would Depp's team argue she abused them?
Yes, while truth was the central pillar of her defense, her team could certainly have argued a qualified privilege. They could frame the op-ed as a statement on a matter of intense public concern, domestic violence, #MeToo, where she, as someone claiming experience, had an interest in speaking, and the public had an interest in hearing.
Makes sense, but then Depp's argument would be...
Depp's counter-argument and the core of his actual malice claim was essentially that she abused any potential privilege. He argued she didn't act in good faith, that she acted with actual malice, knowing falsity or reckless disregard, possibly driven by an improper purpose to harm his reputation and career, and that the statements therefore weren't protected. The entire trial was, in many ways, a battle over whether her statements were true, and if not, whether any privilege applied or was abused through malice. Those prior legal documents became evidence used by both sides to argue about truthfulness and state of mind, directly impacting both the truth defense and any qualified privilege defense.
Fascinating how those defenses and the core elements intertwine.
Okay, beyond the main elements and defenses, are there any other little nuances or factors that come up in defamation cases? Maybe things that don't win or lose the case but still matter? Yes, there are a few other points worth noting from Angela's outlines. One is about mitigating factors. Things like the defendant proving they acted with no malice, in the common sense of ill will, or that they issued a prompt retraction or apology for the defamatory statement. These things are generally not defenses that get the defendant off the hook completely if liability is otherwise established.
So retracting it doesn't undo the defamation.
Legally, no, it doesn't erase the initial harm. However, the jury can consider these factors when deciding the amount of damages to award. A sincere retraction might convince a jury the defendant deserves to pay less than someone who doubled down on the false statement. So they mitigate damages, but don't eliminate liability.
Okay, that's an important distinction. And you mentioned earlier making sure we distinguish defamation from things like false light and IIE.
Right. It bears repeating because the lines can seem blurry sometimes. Defamation is laser-focused on harm to reputation. False light, again, is about being portrayed in a highly offensive way, even if it doesn't strictly lower your reputation. Think offensive misrepresentation versus reputational damage. An IIED requires that extreme and outrageous conduct causing severe emotional distress, with the crucial requirement of proving actual damages, that's severe distress. Defamation, particularly libel and slander per se, allows for presumed damages to reputation, which is a key difference in proof. Understanding these distinctions is crucial because the facts of a situation might potentially support claims for more than one tort, but each has its own path and requirements.
It really shows how the law tries to categorize different kinds of personal harm, even when they stem from similar events. Very intricate.
It certainly is.
Well, that feels like a pretty thorough journey through the world of defamation.
Right.
It really brings us to the end of this deep dive. It's such a critical part of tort law, and as the Depp Heard case showed, it has incredibly real and very public consequences.
Absolutely. We really hope that walking through Angela's incredibly detailed torts notes has helped clarify these complex principles for you. Her outlines are just fantastic for breaking this stuff down, and we're so grateful she shares her hard work with us all.
Definitely. Now, just before we wrap up, we have our usual housekeeping points. First, and this is super important, Angela is a student, remember?
Yeah.
Just like many of you listening, she's incredibly knowledgeable, but she's not an expert yet, and she hasn't passed the bar. This is based on her study notes.
Right. And second, just to be crystal clear, neither Angela nor this podcast is giving legal advice. Nothing we've talked about today should be taken as advice for any specific legal situation you might have. And remember, AI, well, we're helpful, but we're no substitute for doing your own deep study of the law or consulting with a qualified lawyer.
Yeah, good point. Third, AI isn't perfect. We try our very best to get everything right based on Angela's notes, but sometimes we might miss a nuance, or heck, just be plain wrong. We're learning too. Angela, being human, does her best to review and correct things, but always double-check against your own material.
Sound advice. And lastly, a practical tip for everyone studying while commuting. If you are driving, please be safe on the road. That's the absolute priority. Don't cause a tort while you're listening to torts.
Huh. Good one. Uh-oh. If you want to reach out to Angela with questions or comments, the email is podcast@studyforthebarinyourcar.com. And for any lawyers or law firms needing freelance clerk support, research, writing, etc., her professional email is hello@legalwriterandlawclerk.com.
All right, now I believe tradition dictates. It's time for our cheesy lawyer joke moment. Let's see, why did the tort cross the road?
Oh boy. I don't know. Why did the tort cross the road?
To sue the chicken for infliction of emotional distress.
Oh, wow. Okay. That's definitely a torts joke.
Told you, it was cheesy.
All right. Well, this is Claude and Maude, your AI bots, signing off.
We'll see you on the next deep dive.
Goodbye, everyone. And seriously, good luck with your bar studies.